voice of the people, 90.3 FM. My name is Esther Nwachukwu, and these are the top stories. Nigeria wins case against P&ID. President Tinubu reacts as Nigeria wins $11 billion P&ID case. Court receives conflicting letters from Chicago Varsity on Tinubu's certificate. Supreme Court reserves judgment on Atiku's petition against Tinubu. Former INEC chairman Jega clarifies position on 2023 elections being compromised. Details now. Nigeria has won its case against the Process and Industrial Development Company P&ID. In the case, the federal government sought to overturn an arbitration award in favor of P&ID, which has now accrued interest worth $11 billion. The company had claimed it entered into an agreement with Nigeria to build a gas processing plant in Calabar, Cross River State, but the deal collapsed because the Nigerian government did not fulfill its end of the bargain. A London High Court has now delivered judgment in Nigeria's favor. Meanwhile, President Bola Tinubu has applauded the court ruling which awarded a landmark victory to the federal government of Nigeria over Process and Industrial Development Limited. VOP News gathered that Judge Robin Knowles of the Business and Property Court in London ruled in favor of Nigeria and quashed the enforcement of the $11 billion arbitration award in favor of P&ID. Following the landmark ruling, President Tinubu, in a statement today by his spokesman Ajuri Ngalale, commended the UK court for prioritizing the merits of the case above all other considerations. He said the ruling has proved conclusively that nation-states will no longer be held hostage by economic conspiracies between private firms and solitary corrupt officials. President Tinubu added that today's victory is not for Nigeria alone, but a victory for the long-exploited African continent and for the developing world at large. Elsewhere, the Supreme Court today stated that there are conflicting letters from the Chicago State University on the certificate of President Bola Tinubu. VOP News gathered that the chairman of the 7-member panel of the Apex Court, Justice John Okoro, stated this during the hearing of the application of the presidential candidate of the People's Democratic Party, Atiku Abubakar, filed against the victory of President Bola Tinubu. Justice Okoro said one of the letters is authenticating the president's certificate and another is discrediting it. The Presidential Election Petition Tribunal had struck out the appeals of Atiku and Peter Obi of the Labour Party, but they headed for the Apex Court, with Atiku asking to file extra evidence against Tinubu on alleged forgery. Atiku had sought Tinubu's academic record from Chicago State University so as to prove his allegation that the president submitted forged documents to INEC. However, by the time the documents were released, the 180-day statutory period within which an election petition should be filed and determined had elapsed. But Atiku asked the court to grant his appeal to tender fresh evidence, given the nature of the issue. However, Tinubu kicked against this, saying granting such would amount to abuse of the court process. Atiku predicated his plea on the grounds that presenting forged documents by any candidate, especially by one of the highest office in the land, is a grave constitutional issue that must not be encouraged. But Tinubu kicked the plea, arguing that the issue was a pre-election matter amongst others, and subsequently prayed the court to deny the grant of the application. While faulting Tinubu, Atiku submitted that issues of merit ought not to be determined or pronounced upon at the interlocutory stage. The former vice president also pointed out that the presentation of a forged certificate disqualifies a candidate for all time, no matter when presented. Meanwhile, the Supreme Court as well today reserved the judgment on the appeal filed by the People's Democratic Party's presidential candidate Atiku Abubakar, challenging the decision of the Presidential Election Petition Court, which affirmed the victory of President Bola Tinubu in the February 25, 2023 presidential election. The decision was reached by the 7-man panel of the Apex Court led by Justice John Okoro after lawyers to the parties in the case adopted their briefs of argument and made final submissions. The Supreme Court judges listened to the arguments from lawyers and the motion filed by the appellant to supply fresh evidence. On his part, the legal counsel of Atiku, Chris Uche, who is a senior advocate of Nigeria, urged the court to grant the motion, allow their appeal, and accept fresh evidence. He prayed the court to grant the request seeking Tinubu's disqualification. However, lawyers to the respondents, Abubakar Mahmood, also a senior advocate of Nigeria, representing the Independent National Electoral Commission. Also, Chief Wole Olanikbeku, a senior advocate of Nigeria, who is the lead counsel for President Bola Ahmed Tinubu, and Chief Aki Olujimi, a senior advocate of Nigeria for the All Progressives Congress, urged the court to dismiss both the motion and appeal for lacking in merit. The judges thereafter reserved judgment till a date to be communicated to the parties. Meanwhile, after rising briefly, the judges have commenced hearing of the appeal by the Allied People's Movement. After they had dropped the appeal, they stated they no longer will issue that appeal anymore to the Supreme Court. Now, we also have this particular development story where the president has insisted on the removal of the petrol subsidy, saying that change often comes with its share of hardships. The president made the statement earlier today at the grand finale of the ongoing 3-day combined convocation ceremonies of the 37th and 38th academic session of the University of Ilorin. President Tinubu admitted that Nigerians are currently facing economic pains due to the subsidy removal, but he urged them to see the accompanying pains as short-term and look out for their potential long-term benefits. The removal of subsidies can pave the way for investments in alternative energy sources, infrastructure, and public services that will contribute to a stronger and prosperous Nigeria. The president also urged Nigerians to remain united and support one another as the nation navigates through the challenges of the transition. He stated, and I quote, "It's a challenging journey, but by embracing innovation and conserving energy, we can navigate through these difficulties and emerge stronger as a nation." The president also commended the University of Ilorin management for its many academic laurels and contributions to the growth and development of the country at large. Now, Professor Atahiru Jega, a former chairman of the Independent National Electoral Commission, has denied saying that the 2022 general elections were compromised. He made the clarification in a statement today, signed on his behalf by his senior research assistant, Princess Haman Obels. Jega said such a report is incorrect and not an accurate reflection of his position. He was quoted to have said, and I will read, "We have seen in 2023 elections the damaging effect of how people in the corridors of power get their client/partisan nominees appointed without being thoroughly screened, and then they are influenced to compromise the integrity of elections." The former INEC boss was said to have made this statement at a 2-day retreat organized by the Senate in Ikot Ekpene, Akwa Ibom State last week. However, Jega has denied saying such. Professor Jega categorically denied making that particular comment about the 2023 polls. Haman Obels, who is also the director of the Electoral Hub, an initiative for research, innovation, and advocacy in development. Now, I actually have joining me via the telephone a legal practitioner, a public affairs commentator, and also a political enthusiast, Barrister Eze Eluche. Barrister Eze Eluche, good evening and welcome to the World News at 6.
Thank you for having me on.
And thank you for taking your time to be part of the conversation this evening. Barrister Eze Eluche, today the Supreme Court heard the fresh appeal that was meant to be tendered by the People's Democratic Party and, of course, President Bola Ahmed Tinubu. INEC too as well, who, of course, needs to, defend declaring President Bola Tinubu as the winner of the February 25 elections. Well, they have reserved their judgment. But before reserving their judgment, the Supreme Court had complained that there are conflicting certificates or rather there are conflicting letters from the Chicago State University on the certificate of President Bola Ahmed Tinubu. And Justice Okoro said one of the letters is authenticating the president's certificate and another is discrediting it. Do you think this could be the grounds why they reserve judgment? And how do you think this particular situation will affect the fresh plea to tender the CSU certificate at the Supreme Court against the win as declared by INEC on President Bola Ahmed Tinubu?
Well, thank you very much. When the Supreme Court says it has reserved for judgment, it just means that it has adjourned, and the next time the participants or the litigants will get a date to come and read or hear the court read out its judgment. So it's normal that after hearing the pleadings of the parties, of the litigants, the Supreme Court will adjourn and reserve judgment. So that's what that's done. Now, with regard to the statement by the lead justice in that panel, Justice Okoro, that there were two conflicting letters. That was, in my view, a most unfortunate comment. Reason being that there are no two conflicting letters. There is a letter by an individual acting in his own personal capacity, who is the staff of Tinubu University, and then there is a court-ordered deposition, where the court ordered the university to depose to statement of fact before the court. So there are no two documents, no two letters. I don't know how, under what criteria the judges made that comment. Perhaps was in error, because the one letter written by the individual who is the staff of the school that authenticated the Tinubu certificate is totally inconsequential when compared or considered against the position by the university on a court order. So it gives one goosebumps, and one begins to wonder what other things will transpire. But like I said, when they reserve judgment, when they were adjourned and they reserve judgment, this is when there will be a lot of discussions among the judges, a lot of clarifications, because the judge who made that comment made it in his individual capacity. Because every of the judges has the right to make to raise questions, seek clarifications from the lawyers of the party, and just declare. But when the judges now retire to deliberate over the case, it is hoped that this issue will be made clear to each and every one of them. But the fact is this, and that is an undisputable fact: there are no two letters of conflicting on the issue of Tinubu's certificate.
Okay.
One letter was written by an individual who is the staff of the school, and the other one was a court-ordered deposition. Now, the fact that this one is a court-ordered deposition trumps and cancels and overrides whatever any individual could have deposed to. Let me, graphically illustrate it. In the initial letter, which was written for Tinubu by himself or through his process went to the school, saw a school staff. Can you write it for?
Hello? Hello, Barrister.
University to enter into a deposition.
Hello? Oh, we're having a network situation. Barrister, I think we're having a network situation. You seem to fade off and come back. Okay, continue. You're better clear now.
Good. So what I'm saying is, it is preposterous for anybody to begin to imagine that there are two conflicting letters. There are none.
So where did the judges see? Where did they see these conflicting letters? Does it mean that when this was tendered to them, or rather sent to them, they didn't properly go through it? Because for them to state that this conflicting letters, and everyone is possibly afraid that this could affect the judgment, or this could affect the fresh motion filed by Atiku Abubakar for that particular new evidence to be tendered at the Supreme Court going forward.
No, how the court operates is this. There are a panel of 7 of them. Each of them has any right to ask any question for clarification. So it was in one of those questions that one of the justices raised this issue of two conflicting letters. Okay. So it is hoped that when they now retire to consider the totality of the evidence before them, then they'll be able to now clarify among themselves these realities. But the fact is that there are no two conflicting letters. The Chicago State University made only one deposition, which is the one that actually confirmed that the document Bola Ahmed Tinubu submitted to INEC is a forged document. But several other issues cropped up in the course of this appearance before the Supreme Court today. The lawyer for Mr. Tinubu was now saying they should have brought in the person who deposed to the affidavit to court, which is preposterous and ridiculous. Because what is the essence of having a certified true copy of a document before the court? It is that this is a sure sign of the originality. Another funny issue was that the lawyer for INEC opposed the admission of new evidence. You now begin to wonder, INEC is supposed to be an independent electoral body. So what is the business of INEC in opposing something else. But these are things that they got to look into, and before the next day when it will have to deliver its judgment.
Okay, so Barrister Eze, let's look at the Allied People's Movement. If the Allied People's Movement knew that they were going to drop their case, all right, against President Bola Ahmed Tinubu, why proceed to the Supreme Court if you knew that it would be considered as a waste of the court's time? Because when I saw that eventually they had, dropped their case, I wondered why still wait on to get to the Supreme Court if you knew that what the grounds that you tendered would not hold water, considering that the Supreme Court had ruled on one of the issues that they tendered, one of the petitions that they used as a grounds for the disqualification of President Bola Ahmed Tinubu's win on February 25. What's your take on that?
Well, it was one of those unfortunate things that happened when a party goes for counsels which are looking beyond the facts of the case. Because if the Allied People's Movement Council, which is Tinubu, if he felt that he had real issues to bring before the court, he would not just have withdrawn based on the views or sentiments expressed by the justices when they were inquiring or asking questions to clarify issues. Because basically, what the justices were asking was for him to establish to them why they should get involved in that matter, when it was basically a constitutional issue, and that they had no real benefits to derive from that process. But then, one would have felt that having gone this far, having gone to the tribunal, the Allied Movement still had an issue, had a basic right to know the truth and the constitutionality of issue, because it was a political party. It doesn't mean that it must have a candidate who will win, but it was in its own best interest for the court to rule whether the issue of dual candidature should be allowed in future. But the Council for Allied Movement, maybe for fear of subsequent appearances in the court, capitulated unnecessarily. He capitulated because he had already said that with the way the courts were asking the questions, the courts would not likely accede to his request. That was why he capitulated. But ideally, still those questions were constitutional issues, and the party had locus. The Allied Movement had locus to raise those issues. Whether the APM had a candidate that will win the election if Tinubu was disqualified is immaterial. Because if APM does not have a candidate today, maybe at the next election, you have a candidate who can win. So, but it was unfortunate, but I believe if they had had a moral ethical lawyer representing them, that matter would have gone and the court would have been forced to make a pronouncement on the issue. Because at times you go to Supreme Court to decide for posterity's sake. Now, having left that issue, tomorrow we are not even sure what that issue means. So Allied People's Movement disgraced itself by withdrawing from that matter.
All right, before now, the president's legal team had written to the Supreme Court asking it to dismiss whatever fresh motion that, the legal team of Atiku Abubakar wants to present at the Supreme Court. They were also confident during the deposition of Caleb Westberg when they said that the PDP is on a fishing expedition and all they are going through is just is a journey in futility. But there are challenges which the president needs to defend. He may be forced to defend the authenticity of his academic certificate from the Chicago State University, concerning also the controversy surrounding his academic qualifications, which has been ongoing for many years. Now, in 1999, when he was running for the governor of Lagos State, he was accused of forging his academic certificates. In addition to this academic controversy, he is also facing scrutiny over his past. Now, the FBI are meant to release records very soon. There are speculations by one of the spokespersons for APC, Bayo Onanuga, saying that the PDP and the Labour Party wrote to a particular Aaron Greenspan to facilitate the process, like the FBI release those records before, the Supreme Court is done with, so that they can use that as a stronger evidence against President Bola Ahmed Tinubu. But I'm posing it to you, Barrister Eze Eluchi. In all of these conflicting situations, the president being in the middle of this, a couple of critics feel he is confident in how the Supreme Court will rule in this. What do you think that the president's confidence actually holds on a solid ground that the Supreme Court may actually rule in his favor?
Well, certainly, I mean, when you have a case before a court, you will keep on exuding confidence until the very last minute. So I wouldn't blame him for exuding confidence. But the fact and the realities that before us is there is incontrovertible that Mr. Bola Tinubu had submitted a forged document to INEC, and then it is not the court to decide. But the court itself, I'm sure they are not aware of the fact what the global perception of Nigeria will be. Already we are beginning to suffer the consequences of having a president who is known to have submitted forged documents to be elected. One of these consequences is that Nigerians who submitted divorce certificates in the United States of America are now being asked to come and establish the genuinity and the truthfulness of those divorce certificates they produce in American courts for Americans. So there will be more and more consequences so long as we don't do the right thing at the right time. So the confidence being exceeded by Mr. Bola Tinubu is expected. What do you want him to do? To run away? No, we will keep on exceeding confidence until the Supreme Court does the right thing.
All right, Barrister Eze, before I let you go, recently President Bola Ahmed Tinubu via a particular meetup, in one of the 37th and 38th academic sessions of the University of Ilorin, one of their convocation ceremonies, pleaded with people. He used the opportunity to plead with Nigerians to please bear with the subsidy removal. He said that it was important for subsidy removal to be removed, that it wasn't helping anybody, and that he also shares in the hardships of Nigerians. That's one of the things he said. But two months ago, was it a month ago, the president went to the United Nations General Assembly, and you need to know the budget that was, put aside for his expenses, his hotel reservations, including those of his aid. Also, you recall that about 160 billion naira that was earmarked for SUVs that will be given to the recent House of Rep members. Now, we do know that the cost of governance has not reduced, but the president is asking people to bear the hardship, to bear the pain of subsidy removal. We have companies, more than 10 companies that were opened in Nigeria had shut down. The economic hardship is so much. The forex is one of the situation. Security too is another problem. These companies are strong companies that have helped employ the productive society, that is, they're part of the labor market. They've employed a lot of young persons. Now they've closed down. So we now have more persons looking for jobs in the labor market. Pastor Eze Oluche, how do you see this turning out from now to the first quarter of 2024?
Nigerians don't take the words of the president serious when he urges them to tighten their belts. And the reasons are very clear. You cannot be telling people to tighten their belts when you are losing your own belt. You have now, this same president who is saying to tighten our belts because of economic hardship has had now the largest cabinet, more than any other president ever in this country, of Nigeria. Almost 50 ministers. He has more than 27 special assistants on media, only on media issues. I'm sure by the time we are all through, we may have more than 500 special assistants.
Barrister Eze, I need to mention these companies that are shut down. These are reliable companies that had over 100 staff workforces with them, and these persons have been displaced. Louis Carter Industries, Mook Enterprises, Procter & Gamble, Tar Aluminium, GlaxoSmithKline, Mayor Biscuits Company, Technoflex Company, Multitracks Integrated Food. These are food companies that has a huge, employment opportunity. They employ a lot of Nigerians because it's like a factory. All right. Shores Firm Limited, Freeman Industry, Delhi Food, Stone Industries, more than 10 of them. All right. P&G as well. These are strong companies. They've all shut down. And one of the reasons that they shut down was basically because of high energy costs, the slowdown in industrial output, and a sluggish demand for products, among a plethora of issues debilitating manufacturing activities in Nigeria. Over 10 manufacturing companies operating in Africa's most populous country. They've halted operations in the last 10 years over worsening macroeconomic challenges. And at the moment, it doesn't seem to be reducing at all. The naira is now about 1,100 to $1. So there is an expectation that more companies may shut down, more entrepreneurs may close up their businesses because they can't meet up with payment and even production. What should people do now?
What is the question?
That's the question. That's basically it. What should people do now amidst the statement that the president made at the University of Ilorin concerning Nigerians being patient or understanding the reason for the hardship on the removal of fuel subsidy?
Well, the fact is, that's why I say people don't simply take this government serious when they make such promise or such comment, because there's no plan. Rather, they are still expanding their own belt to eat more, to have more of the national resources to their own pocket. So, I mean, nobody takes this government seriously in their comments. People are now doing whatever they can do to survive. Because everybody is to your own, on their own. There's nothing like any government. But we have a state of lack of governance in the country. Because those who are in charge of their affairs are busy taking care of themselves, and they're acting like they're so tightening their belt. What are you going to tighten your belt? There's no belt again to tighten. So that is the reason. That is the more reason why we are hopeful that the court will give a more definitive judgment so that Nigerians will have hope again. Under this regime, there's absolutely no.
All right, Barrister Ezra, thank you so much for your time on the World News at 6. I sincerely do appreciate your input. Thank you. All right, to wrap up the world news, here again, now the top stories. Nigeria wins case against P&ID. President Tinubu reacts as Nigeria wins $11 billion P&ID case. Court receives conflicting letters from Chicago Varsity on Tinubu's certificate. Supreme Court reserves judgment in Article's petition against Tinubu. And former INEC chairman Jega clarifies position on 2023 elections being compromised. That's a wrap on the World News at 6 right here on Voice of the People 90.3 FM. My name is Esther Wachuku. Good evening and thank you for listening.